don't have to write this part, but sometimes during times of war and other crises, I guess I'm on the screen. Sometimes during war and other crises, Americans are willing to give up liberties and freedom that we're accustomed to having. And it's happened not just in American history, but in world history. And typically during times of war, the first rights that go away are going to be the First Amendment, which is freedom of speech, right to assembly, freedom of religion, freedom of the press, right to petition. The Fourth Amendment, the Fifth Amendment, sometimes during times of war, we're willing to give those things up. And during World War I, that is a time when that happened. So during World War I, we're going to have people who were conscientious objectors. And a conscientious objector is a person who refuses to serve in war. A conscientious objector is someone who refuses to serve because of religious or political reasons. A conscientious objector could be a pacifist, a person who just does not believe in fighting. A conscientious objector could be a person who, for religious reasons, does not believe in killing or participating in war. It could be a person that, for political reasons, they don't support the war. During World War I, we'll have about 4,000 conscientious objectors. And what they have to do is they're sent to work camps. And they're sent to work camps, and there they have to do jobs that support the war effort. This is a very debatable topic. Okay, because you guys you could debate that patriotism means that you serve your country no matter what. You could argue that they weren't actually fighting in the war. But at the same time, you could argue that they're still supporting the war and that we have religious freedom and that if you don't support a war, then you shouldn't have to. So when we debate tomorrow, make sure that you bring this up, because this is definitely a topic that you could look at. Okay, do you have questions or comments? During World War I, Congress is going to pass the Espionage Act. The Espionage Act goes completely against the First Amendment. The Espionage Act made it against the law to say or publish anything that went against the war effort. So it made it against the law to give speeches against the war. It made it against the law to criticize the president. It made it against the law to criticize the government. You could not publish or mail anything that went against the war. You could not say anything negative about the war, the government, or the president. You could actually be sentenced to prison for this for up to 20 years. You could have to pay a fine of up to $100,000. And during World War I, there are going to be people who are prosecuted under this. One of the people who's prosecuted under this was actually running for president. And one of the things that he said while he was running is that we should get out of the war. And he went to prison for it. And again, this is a debatable topic. You can talk about, patriotism, or you could talk about that's against the First Amendment, and why are we fighting if we're taking away the things that we're actually fighting for? You could debate that in order to preserve those freedoms forever, give them up temporarily. There's so many sides to this that you can look at and that you can argue. So make sure that you bring those things up. Okay, do you have questions about this? Do you need a minute? need a minute? Okay. Okay, don't try to write all this because it's a lot. The Sedition Act was passed by Congress in 1918. And what the Sedition Act did is that it expanded the Espionage Act. So the Espionage Act made it against the law to speak out against the war effort, the president, or the government. But the Sedition Act made it to where it was illegal to do anything that interfered with the war effort. So, for example, it was against the law to go on strike because a strike could hurt the war effort. It made it against the law to even publish something that encouraged people to go on strike. So anything that interfered with the war effort whatsoever, you could be punished for. And again, the punishment for the crime was the same. You could be imprisoned. You could be fined. Again, First Amendment. We're allowed to say what we want. Freedom of the press. But we allowed this to happen. And of course it was challenged. Okay, so what we're going to do now is we're going to look at the challenges of this. Because people will challenge these two laws. And both of these laws will be challenged in the Supreme Court. And I want to talk to you guys about the Supreme Court for a minute, since you haven't had civics yet. So, a lot of times in American history, we study laws. Somebody versus somebody. That means that was a Supreme Court case. And the Supreme Court, what they do is they interpret the Constitution. And their rulings create law. They interpret laws, but when they rule on something, it's like they created the law. Does that make any sense? Okay, so the Supreme Court is the highest court in the land. In order to go to the Supreme Court, you have to first go to a federal court. Then you go to an appeals court. And then you can go to the Supreme Court. The Supreme Court doesn't hear all of the cases that's brought before it. Shh, girls. These are where federal courts are located. So first you go to federal court, then an appeals court, and then the Supreme Court. The Schenck case, and you do not have to write all this, that would be insanity. The Schenck case of 1919 challenged the Espionage and Sedition Acts. Charles Schenck published and mailed anti-war material. He was arrested. He was imprisoned. He appealed his case. His case went to the Supreme Court. This is how the ruling went. It said that in many places and in ordinary times, he would have been able to publish these materials, but that freedom of speech and other rights are limited in times of war if it produces a clear and present danger, then speech is limited. And so they compared it to shouting fire in a crowded theater and causing a panic. So the conviction was upheld. Okay, does that make sense? Other challenges. You don't have to memorize the other challenges, but I just want you to know that he's not the only person to challenge it. The other challenges that are brought to the courts, they're also going to rule clear and present danger. That free speech is limited when it causes a clear and present danger. Does that make sense? You don't have to memorize these. If you can memorize the Schenck case, and if you can memorize the phrase clear and present danger. Okay, questions, comments? we're finished.
Okay. Can I ask you a question?